This is panel 2. We're going to be talking about competition policy and trade imperatives in Africa, inevitable tensions, and our speakers are going to give us some diverse perspectives on that. I think all of us agreed in our prep for this panel that the most taxing aspect has been dusting off our suits and trying to find our high heel shoes. I think many people in the audience look like they may have had the same problem, but thanks for joining us. It's great to see all of you. And as X said in his address this morning, really wonderful to see everybody in person. And we're so happy we can do this again. The African Continental Free Trade Agreement will create an economic bloc of about 1.3 billion people, which will be the world's largest trade zone. Preferential trading agreements between the member countries will need to be unbundled to allow for wider cross-border trading, creating a wide range of much more competitive African markets and enormous flows of imports and exports. However, the potential tension between these trade imperatives and competition enforcement has been highlighted in South Africa recently, in particular since the formulation of our various sector plans and the policy statement on competition for policy for jobs and industrial development, which was published by the Minister for Trade, Industry and Competition last year. In that document, Minister Patel identifies the important role played by the Competition Act and what he calls policymakers, I think he means the Competition Commission, in promoting greater localization as a means to increase industrialization and increase development of the South African economy in a more inclusive, transformed and vibrant way. The Competition Commission has taken on board this imperative and is already starting to ask merged firms what they can do to contribute to localization in the context of merger reviews. In addition, the Commission has released a draft guideline which help assist South African companies to understand how they can collaborate in ways that support localization, for example, by setting targets for increased local procurement. At the same time, we've seen an increased use of protective trade measures, including safeguard duties, which have been applied to shield local South African businesses, including in areas of the economy where we've seen former monopolies engage in excessive pricing, like steel. New restrictions in the Competition Act, which have yet to come into force, will inhibit the ability of foreign investors to compete to invest in South African markets. So this is what our panel today is going to be discussing from their unique perspectives. I'd like to welcome our panel and thank them for joining us, especially those of you who gave me a heart attack because I thought you might not pitch up. First, I'd like to welcome Baki Majenge. He's the Legal Services Division Manager and Acting Deputy Commissioner of the South African Competition Commission. Next to him is Tatenda Zengeni, Senior Researcher at the Zimbabwe Competition and Tariff Commission. Then we have Phil Alves from Berkeley Research Group. He's an economist in their team there. And my partner, Lebohang Mabidikane at Bowmans in the Johannesburg office. And last but not least, Mr. Thomas Janssens from Freshfields, who gave us a heart attack about his not being here, but has luckily managed to come in just exactly on time. You're most welcome, Thomas. Baki, if I can ask you to kick off, would you like to give us some perspectives from the South African Competition Commission to things like localization, perhaps in merger control, and also speak a little bit about your draft guidelines?
Thank you, Heather. Morning to everyone. I must first start with a disclaimer, Heather, that I will not be speaking on behalf of the Commission unless the context indicates otherwise. Let me perhaps start with two observations. The first observation is that localization essentially is an industrial policy instrument that lies within the domain of policymakers and not necessarily competition regulators. The second observation is that the concept of localization is quite a broad concept, which is amenable to different interpretations. And where the objectives of localization intersect or overlap with some of the public interest provisions of the Act, then in that sense, then it could be said that the public interest grounds in the Competition Act promote localization. But that is not necessarily the primary objective, because the primary objective of the public interest provisions of the Competition Act is to secure the public interests which are recognized in the Act. For instance, localization intersects or overlaps directly with the public interest objective relating to impact on industrial sector or region. So where a merger has such an impact, interventions to address that impact and to ameliorate that impact and to craft remedies to address that impact may then intersect or overlap with localization. But I would suggest that the primary objective of this public interest objectives of the Competition Act is not necessarily to promote localization, because that is not expressly referenced in the Act. And of course, the supplier development funds, which have been imposed within the context of merger control, if one looks at them, they are essentially aimed at creating or unlocking value chain opportunities for smaller suppliers, or promoting entry by smaller suppliers. So one can then see that such an outcome then dovetails with the objectives of localization in that sense. In fact, interestingly, the Masmat Fund, which was really the first of its kind within the context of merger control, actually set the trend for other measures that followed afterwards in terms of crafting supplier development funds within the context of merger control. And I must say that this was not, as we all know, at the initiative of the Competition Commission, but this was ultimately an initiative that ended up being secured through the Competition Appeal Court. And I see that the Judge President is here. And in fact, we have done a study of the impact of that fund. And we found that it has created significant opportunities for smaller suppliers. Maybe let me pause here, Heather, then we can return to the issue of the guidelines in order to give my colleagues an opportunity to also speak on the issue. Thank you.
Yeah, thanks, Bakhe. So if I understand what you're saying the Commission is about making opportunities, and this can sometimes be applied through merger control, not necessarily in the business of requiring that firms switch away from imports, although that may be a consequence of fostering local markets. Is that right?
Yes, I think I have to make the point very clear that one of the important public interest grounds that the Commission has to engage with is as we all know, the impact of a merger on an industrial sector or region. So where that impact is apparent or indicated, and there's a need for an intervention, that intervention may take the form of a remedy to promote, for instance, local farmers, suppliers, local value chains. So that kind of a remedy, although it looks like localization, it's not necessarily localization, but it's primarily aimed at addressing the public interest, the public interest issues that may arise from a transaction. So it's really an issue, as I see it, of overlap and intersection, or even one could even venture to suggest coincidence, but the objectives may be the same as localization objectives.
And not necessarily the same as the kind of policy instruments that state buyers would apply, for example, where they say we will not buy a particular product unless it has a minimum local content.
Yes, it's not a full or a hardcore, these are not full hardcore industrial policy interventions, because that lies within the domain of government or policymakers. And to use measure control in a way that is geared towards promoting industrial policy, measure control may not necessarily be the appropriate instrument for that. But the objectives, the public interest objectives may coincide with the objectives of localization. So I think, yes, I think it's really an issue of labeling as I see it, because it's very easy to label these major remedies as localization, but that is just a label, because if you look at the real substance of the interventions, these are public interest interventions.
And then, as I understand the Commission's draft guidelines on collaboration, those do anticipate that local competitors might want to get together and agree on targets. For example, we will purchase 50% of a particular input locally in South Africa rather than importing it, or we will decrease our imports over time. Presumably that guideline is meant to facilitate that kind of conduct.
Yes, in terms of the guidelines that the Commission has been issuing in terms of Section 78 of the Competition Act, those guidelines are not aimed at regulating localization, because the Commission is not the regulator of localization. Those guidelines are aimed at creating a framework for ensuring that policymakers or the private sector, should they wish to engage in localization initiative, they should do that in a manner that does not give rise to coordination or to cartelization. So that is really the primary objectives of the guidelines, to ensure that localization is done in a manner that does not hurt the Competition Act. So that's really the primary objectives of those guidelines. And you can even see from the guidelines themselves that in the manner in which they have been crafted, we do envisage that these initiatives will have an exit point. They are meant at addressing a particular problem, and at some point there will be localization will be exited. I think a case in point is the guidelines that we published in relation to the sugar cane industry. It is very clear that the guidelines are responding to a master plan, a 3-year master plan. Then after that, according to the master plan, localization will be exited, because the intention is to respond to the current challenges facing the South African sugar industry, which we all know. And part of the objectives of localization as we understand it, hence we are sympathetic, but not necessarily primary sponsors of it, is that it has linkages to a number of other objectives, including, for instance, job preservation, as well as job creation. Thank you, Heather.
Thanks, Bakhe. Tatenda, moving on to you, would you like to give us some perspective from Zimbabwe, similar sorts of measures being put in place?
Okay, thank you very much, Heather, and good morning to everyone. I think from the Zimbabwean side, let me start by, maybe I have to highlight this in the beginning so that I think it's actually important in terms of the context of our discussion. So in Zimbabwe, what we have is we have got a combination of the Competition Commission and the Trade Tariff Commission. So our institution is called Competition and Tariff Commission. So we have got a mandate to promote and maintain competition. And we also have a mandate to ensure that the local industry is very competitive in terms of offering assistance to local industry. That is through basically tariff review, where you reduce tariffs on raw materials to allow the industry to become competitive, and also review tariffs upwards in order to, I didn't want to use the word protect, but to protect your local industry. So we have got that kind of unique institution. I think I've researched around it. I think it's only us who have got that kind of unique institution. Now looking at localization, I think I must be very clear here to say, in Zimbabwe, what we have observed prior to COVID and even during the pandemic is the rise in this lobbying about localization. We need to buy local and so forth. And that actually created an organization called Buy Zimbabwe, which has lobbied with government to come up with a local procurement policy, which is now in force. However, we don't have those kind of regulations that force us in our law, in the competition law itself, to say when you're approving a merger or when you're dealing with a restrictive practice case, you have to look at issues to do with localization. We don't have that in our act, but we have got sort of a flexible public interests law that we, in Zimbabwe, it's not a prescribed, it's not defined in our law to say public interest is such. It's not prescribed. So what we have done in the past and what we continue to do now is, in a number of cases, we have approved measures conditionally. I will give like an example. I think most of you are aware of the Coca-Cola Schweppes measure. In Zimbabwe, it was approved conditionally. And some of the conditions there, one was to say Coca-Cola, apparently Schweppes in Zimbabwe had a brand called Mazoe. I think some of you are very familiar with that good taste of cordial. Yeah. So there were Schweppes in Zimbabwe was producing Mazoe. Then there's another brand called Calypso. So when that measure was approved, there was a condition that Coca-Cola must maintain those brands and they must be registered in Zimbabwe, and they must also make those brands regional, and which is something we did an impact assessment in 2019. And when we were meeting with Schweppes in Zimbabwe, they were actually telling us that Mazoe is now regional. They are selling Mazoe all over Africa. So it's something that came out of the public interest issues. Another example again is on AB InBev and Submiller. Apparently in Zim, Submiller controls a company called Delta. So they were also producing a local brand for beer lovers. It's called Bollinger's and Zambezi. And we also applied similar conditions to say you must continue producing these two brands and also make them regional and international. So we have got this kind of public interests where we can actually navigate our way through localization. And I think if you were listening to what our presidents were saying last week, they were talking about the need for us to produce our own vaccines and things like that. So this is an issue that is coming from heads of state, and it's something now that why we don't have something in the act that says you must do A, B, C, D, and E. So we try by all means to factor that into into our analysis and into the work that we do on promoting and maintaining competition. Maybe I will also speak about the unique setup that I spoke about. So what you have now, remember I said you have a competition commission and you have got a trade tariff function. So there is an application for a company applies for duty review upwards protection. It applies and say, we want protection. We are facing stiff competition, blah, blah, blah. The moment they say stiff competition, we also have competition people who are sitting there. So we have got that kind of internal kind of regulation within the commission. And that results in what I would call an optimal kind of enforcement of competition law in Zimbabwe. I think that is what I can say for now.
Fantastic. Thanks very much. And before we get to the rest of the panel, I'm going to take any questions. Does anyone have any questions or comments at this point? Yes, go ahead.
Tatenda did mention Schweppes Coca-Cola merger, and I just wanted to say I played a prominent role in that merger, and I was involved in the AB and InBev merger. But the important point I want to bring home, apart from bragging about what I did, is to say that the attitude of the Competition Commission has always been to say we will advance the interests of the economy over and above sectorial interests. And that has always, all the dealings that I've had with them, that's always been the driving force. What is this going to benefit the economy? How is this going to benefit the consumer? So I think they still maintain the same attitude, and it's really a commendable one.
Question or comment? Okay, great. Phil, let's turn to you. Any thoughts from an economic perspective?
Thank you very much, Heather, and thank you for inviting me on the panel. Good morning, good afternoon. What time is it now? Good morning. Good morning to you all. Where to start? It's a huge field. I'm excited to be talking about it. I used to do trade policy work before I turned to competition and regulatory economics work. My career has kind of followed the trends in development policy, kind of unwittingly, not on purpose. But I joined the Competition Commission as the global financial crisis hit. And the global financial crisis basically ended the supremacy of thinking in development economics, or at least orthodox thinking in development economics, about the primacy of trade liberalization as your kind of spearhead for driving economic development. So this is a very interesting topic for me. I guess 2 or 3 broad. I mean, it seems to me that recent industrial policy discussions around localization under this new master plan framework, and even more broadly, it's been described as a reimagined industrial policy for South Africa. I suppose that's in reference to the industrial policy efforts that were made or kind of emerged in the aftermath of the global financial crisis and were implemented until about 2018, 2019, when this conversation started about reimagining industrial policy. But I think for me, the first observation is that, I mean, localization, the word is new in the debate, and some of the methods that localization, or some of the methods being promoted in order to promote localization, I guess are new as well. So encouraging more domestic procurement. Government, I think government said no to ever using imported cement, or something along those lines. That's kind of new, but the shift after the global financial crisis has basically been towards increased trade protection and increased intervention in the economy through various industrial policy tools, trade policy being a big one, and that is all a drive to localize. So what we seem to be adding now is as I said, new, different, additional tools, I guess, to try and accelerate the localization process. The other, I guess, big observation is that this feels pretty old-fashioned. This feels like pretty old-fashioned import substitution. So we've seen on the trade front, we've seen anti-dumping duties being used much more intensively and extensively. We've seen increases in most favored nation tariffs under our WTO commitments. We've seen subsidy programs since the re-emergence of industrial policy around 2009 and 10. And we now seem to be, as I said, accelerating that thinking with more explicit and direct measures to protect domestic producers in various sectors. And I guess the high level observation has to be that the impacts or risks of this particular policy approach surely lie in potential price increases, inflationary pressure. Many people have observed that, and do seem, on the face of it, and I can't claim to have spent many hours thinking about it in detail, to work against the sort of basic and core objectives of competition policy and competition law as we've understood it. Public interest concerns, setting them aside for now. But, competition law enforcement has been about preventing mergers or blocking mergers that might increase prices, discovering cartels and preventing, ongoing effects on prices from price fixing agreements, preventing dominant firms from raising prices through various different abuses of their dominant market position. I mean, there seems to be an obvious and very clear tension between that broad objective and a sort of renewed or accelerated commitment to trade protection, sort of defined very broadly. And then the other obvious tension for me is, we have a commitments to the WTO, but also to different regional integration arrangements or regional trade agreements, the latest being the Continental FTA. I mean, I think that localization and various other industrial policy tools are also creating some obvious tensions with the objectives that those other processes have been trying to achieve and have said they want to achieve going forward. So I'll just leave it there for now. Thanks.
Thanks, Phil. And then we thought, going into this African continental free trade world, it might be interesting to hear from you, Thomas. How are these tensions being balanced out in the European context? And do you see the same tensions at work?
Thank you, Heather. Is this working? Yeah, it's working. Yeah, good morning, everybody. Also very happy to be here in person again. Also, before starting, would like to echo what Judge Davis said about Rob Lee. Really, I'm ever grateful for having known Rob for what he did in terms of the collaboration between our firms, Freshfields and Bowmans, and also just for having him as a friend. Turning to the topic today, it's actually a great coincidence that this week saw the first EU-Africa Competition Summit. And that clearly will build a platform for collaboration on all sorts of issues and exchange of ideas. So that I can only encourage that, because that's something that I really support very much. The topic, indeed, you see globally this tension between regional integration and protectionism. And in Europe, that's in a way a tension between the integration of the single market on the one hand, and then national interests that continue. So I'll briefly speak about maybe first of all how EU competition law is a tool, has been a tool for regional integration. Then I'll speak about some of the trends towards protectionism that we see in Europe, and then I'll speak finally about some initiatives where Europe as a whole is acting in a way against the rest of the world. So first of all, on the first slide, I don't know whether somebody can turn the slide, but it's not essential. On EU competition law, maybe a few words on the one hand on state aid and on the other hand on merger control. If you imagine 27 member states in Europe, which form in a way a single market where goods, services, capital and persons really move freely. That's how it operates, at least on paper. But you also have national interest, and you have actually 27 member states which have a varying degree of economic development. Some of them are former communist states where they had state-guided economies. So obviously the notion of state subsidies historically has played a very important role there. Now in Europe we have this quite unique system of state aid control. Essentially, state subsidies need to be approved by the European Commission, either individually or through block exemptions. They need to be notified before being implemented, and the state aid rules are directly applicable in all the member states. There's essentially no other jurisdiction that has rules like that to such an extent. The US does not have this, other confederations don't have it, and it goes beyond, for example, what you have at WTO level, because WTO of course also has its anti-subsidy rules, but those are focused on goods. They're focused on specific types of subsidies. They don't have this pre-authorization. It's really only when there's a complaint from another country. And the remedies also in WTO are prospective, whereas in the EU, if state aid is found to be granted illegally, there's an obligation to the member state to recover the aid, so to get the money back. So that's state aid, and I'll come back to how that plays nowadays. On the other hand, you have merger control. We have a one-stop shop, as you know, at EU level for transactions that meet certain thresholds. That is based, the EU merger review is based on competition law criteria. We have the same debate ongoing and going back to the first panel of today as to what actually is covered by those competition law criteria, and whether aspects like protecting the environment, protecting employment, etc., can also be part of that. But that's an ongoing debate, and I won't go further into that. But you have a tension also between, EU merger control and member states protecting their their national interests. Essentially, the EU merger regulation prohibits member states from interfering with the EU review and with mergers that are cleared by European Commission, except on some very, very specific grounds, grounds that relate to public security, plurality of media, and prudential rules. But that is something which, well, regularly pops up, and it's fair to say that nowadays there's more and more tension there as well. And for example, recently, the European Commission started proceedings against Hungary because the European Commission had approved a merger in the insurance industry, which also affected Hungary. And Hungary actually introduced a law which it labeled as a foreign direct investment law, and prohibited the merger locally on that basis. So there you have a clash. And that takes me to the next slide, which shows some of the competing interests which you see nowadays. The tension between integration and localization, if you want, within the EU. And this has been a seesaw, or maybe even a roller coaster, in terms of trends towards more integration and trends towards national interests and some protectionism by individual EU member states. So first of all, on EU state aid, for example, it's pretty common ground that state subsidies, state giving money to certain activities, to certain companies, that is called by the prohibitional state aids in Europe, except for the exceptions, as I mentioned. But member states have gotten smarter, and they've wanted to promote their local industries. And for example, they've introduced tax schemes to attract big tech companies. And cases involving Apple and Amazon were brought by the European Commission, telling off member states, for example, in the case of Apple Ireland, for actually having sort of covered kind of state aid measures through essentially favorable tax regimes. Now, in that particular case, actually, this was challenged before the European Court, and the European Court actually concluded that this did not, or that the European Commission at least did not show sufficiently how this was a specific tax, specific state aid that would favor Apple. So that's a tension which you see there. A second one is, for example, in merger control, where a number of mergers in Europe may be driven by the threat from competition, say from China. A good example there was the merger between Siemens and Alstom, two companies that manufacture trains. And one of their key arguments was, look, we need to do this because we need to build a European industry because the Chinese are coming and the Chinese are going to take over. And the European Commission actually didn't buy that. They said, no, this is going to limit competition, and we don't see the Chinese there yet. This is way too far into the future. And so the mere fact of creating a European champion is not sufficient to approve your merger. Now that created a whole political upheaval. And actually the ministries or the finance ministers in France and Germany actually published a manifesto urging the European Commission, and they were then later on followed by other member states like Italy and Poland as well, urging them to actually not be so naive about this issue and to amend EU merger rules to account for this kind of threat from outside of Europe. So in a way, protecting Europe. Now, again, the European Commission itself rejected that, at least under the competition rules, and I'll come on to some of the initiatives outside of competition law that this has generated. Finally, I should say, okay, European champions, that's one thing, but a number of member states also try to promote still national champions. They try to promote mergers between, for example, national energy companies, telecom companies, transport companies, to in a way make them stronger against threats from even competition in other member states. And again, that is something which the European Commission has consistently really rejected as a driver for those mergers. So those are some of the sort of the competing interests which you see at the moment, where on the one hand, member states try to look after their own interests, the local economies. I mean, at the end of the day, these are local governments which need to be elected and need to support locally. And it's easier to blame Europe in many cases than it is to actually sort of stand behind European integration, except where it is sort of to form a front against threats from the outside. And that takes me to my third and final slide briefly. First of all, there's the area of foreign direct investment, where member states, again, on the one hand, protect their national interests against investment from outside of Europe. This is not the same one-stop shop as we have in merger control, but we have by now 18 EU member states that have introduced some form of foreign direct investment control. And the European Commission does play sort of a coordination role. So there is a tendency towards more integration there as well. But as I said before, on the example of the Hungarian blockage of the insurance merger, you have some tension there, which you will see also in the future between sort of EU interests and national interests. So that's foreign direct investment. Secondly, and in response to everything coming out from, in particular, the Siemens Alstom case and sort of the political backlash which it's generated, is a proposed new instrument on foreign subsidy control. So this is essentially, in very simplified terms, applying the logic of EU state aid rules, but to state support from to companies that are based outside of Europe and come and do business in Europe, come and acquire companies, come and compete with European companies, come and participate in public procurement. And they're essentially, for example, for mergers, this proposed tool would require an additional notification of, say, if a Chinese controlled company, which may benefit from state support, but also, for example, a sovereign wealth fund from the Middle East coming and acquiring a European company, there would be a check and a review as to whether this, in a way, would distort competition within the European market. So that's an important development. I couldn't talk about this topic without briefly saying something about Brexit, of course. And where I said sometimes it's sort of the European member states joined up against the rest of the world. Now there is an additional sort of outsider, which is the UK, of course. And clearly Brexit has, in a way, generated quite a lot of energy among the remaining member states in terms of pulling together. The UK is now a third country. There is a trade and cooperation agreement in place. But for example, the EU has already indicated, and EU member states, a lot of concern about the much less strict framework for state subsidy control, which the UK is looking at. Now, interestingly, for these purposes, for the foreign subsidies tool, the UK would also be a third country. So that's in a nutshell sort of some illustration how this sort of this seesaw you see between integration on the one hand and localization or protectionism on the other hand, also in Europe.
Very interesting. Thank you, Thomas. We're going to pause there and see if anybody's got any comments or questions.
So my question is to both Bakhe and Thomas, and I wanted to ask, just in relation to foreign direct investment and ministerial intervention in mergers, to Bakhe, where are we seeing that going with the new amendments, giving the minister sort of greater powers in direct engagement with the merger process, along with the commission? My understanding is previously, parties would have separate discussions with the minister, and, he would intervene in the tribunal process, and ultimately conditions would be extracted. So I wanted to know if there are current, synergies between the minister's, involvement as well as the commission, and Thomas, how that process also works from a European perspective, especially where there are different member states involved in different political sort of involvement.
Yeah, in terms of the ministerial role in merger control, we know that the Act demarcates the role of the minister to public interest issues and to engage with public interest issues. I don't think there's anything wrong in that legislative policy approach, especially when one is dealing with public interest, because obviously the minister is best placed to engage with some of the questions arising from public interest issues. Of course, that doesn't, of course, deauthorize the Commission as well as the tribunal from engaging with those issues. But I think the safeguard, I would say, in the process is ultimately the oversight role that the tribunal plays in the process. So I think the demarcation has been crafted quite carefully in the Act. There is certainly a role, in my view, for the involvement of the policymakers in public interest issues generated by major transactions.
Thomas, in Europe, I think the question was, how is this all juggled?
Yeah, exactly. And the reality is that they are sort of separate processes, and it makes actually sort of getting all the necessary approvals for major transactions very complicated. Especially because we have, and this is still in development, so you often see new regimes coming on stream in the course of a transaction, and then you sort of need to notify late in the day and try to sort of fit all of that into a timeline. So it is, as I said, at the moment, 18 member states, potentially 27 member states for foreign direct investment on the one hand, and then it's a transaction with an EU dimension, the European Commission looking at it from the merger control perspective. Now, as I said, on the foreign direct investment, you do have now a cooperation mechanism, and the European Commission tries to streamline that, but they are not the decision maker there. They are just trying to make sure that member states speak to each other, that they look at the right kind of interests to protect, and trying to avoid too much divergence as well. But it raises quite a bit of complexity, and it will be interesting to see whether over time, especially if sort of on the foreign subsidies, there is sort of a common regime, whether over time we also get a common regime, so a bit like CFIUS in the US, but then at the EU level, but we're far from there.
Thanks. There was a question.
Those questions for Thomas. Going back to the foreign direct investment sort of second leg of merger analysis, so where you say you would look at whether the acquirer has been assisted by the estate and the like. I mean, currently is that looked at intra, EU, where, for example, if somehow Italy comes out of its slump and decides to go buy companies throughout the rest of Europe, would that be a problem for the EU where they would have an influence? Or is it solely because it looks at members outside of the EU? And so that's what I would like to know, if they've thought about that.
Yeah, no, it's a great question, because I mean, indeed, typically, say a company that has links to the government of a given member state, which invests in another member state, that should not sort of set off the alarm bells in terms of national interests, because that's the idea of the common market. And on top of that, the EU treaty actually has a provision which says that sort of it's neutral as to the source of ownership, whether it's state ownership or private ownership. So that should not play a role. So it's looking more at the outside, and so it's, for example, looking at whether a Chinese company buys into, say, an electricity grid, and the question that raises in terms of the security of supply within Europe and the threats this could raise. I say within Europe, but I mean within the different member states. But it's pushed pretty far, because we now also, for example, see some of the private equity funds, for example, where at a very high level there might be sort of a very limited investment by the Chinese, and that already triggers off when they invest, say, in certain infrastructure, quite some concerns from those member states. But it's really aimed mainly at, in a way, I mean, it's a political instrument at the end of the day. So it is about, is the company investing, is it a friend or a foe, essentially? Yeah. Yeah, no, exactly. Typically, that is not seen as sort of something of that pertains to the national security. But
only because you're not a Man
actually,
City
there's
fan.
yeah, but there are some. I mean, for example, the French, when I think it was Kraft was planning to, or Unilever, I forget who it was planning to buy into Danone, yogurt producer. That was seen as sort of a national, an asset of national interest, and so essentially how it happens very often, and likewise, for example, when I mean, a number of years ago, there were talks that Pfizer would acquire AstraZeneca, a UK-based company, and the UK was up in arms, and so the political level then, in a way, starts raising noises about, oh, this is against our national interests, etc. You also saw it, by the way, in the NVIDIA ARM deal, which recently tanked, in part because there were these potential concerns. And there you can sort of see, okay, chips, that goes maybe more closely to sort of what could be strategic interests of a state. But my point is that often it is sufficient for governments to sort of raise these issues for these deals then to become de facto very, very difficult to implement and to pursue.
Thanks. Any other questions? Yes, go ahead.
Thank you. Mine is to Bakhe and Tatenda. Bakhe appears to be supporting and justifying the role of the minister in these public interest issues. And obviously, it justifies that further that there's a safeguard at the tribunal level. My question then is that, don't you think there's a risk of congesting public interest issues with political issues, if I may use that, because the minister is a political authority? And then don't you think then Judge Dennis remarks this morning that we should not be seeing public interest as this floating ghost or somewhere which is completely separated from competition assessment? So if we are giving that big role to the minister, don't we then actually completely divide that integration between public interest and competition assessment pure? And then even if there's that safeguard at the tribunal level, don't you think perception and psychological influence still, I know we'll talk about objectivity and everything, but humans are humans, and influence and psychological influence and perception is very important in these issues. So I'm not so sure those safeguards would completely eliminate the political issues finding themselves under the guise of public interest, but I'll hear more from you. And then Tatenda, the Zimbabwean major control provisions, in fact, the COMESA competition regulations, major control provisions are a copy paste of what is in Zimbabwe, Zimbabwean law, word for word. And one of the issues we've had is that issue of public interest. Because in our view, if you look at the major provisions purely, we failed to find a provision that would support public interest as it is non-traditionally, because we look at those things to be pro-competitive matters. We've over the past obviously tried to push in that, but not from the major control provisions per se, but from Article 2, which talks about public benefits or something like that. Now, I heard you said, even if it's not properly defined in your law, the Zimbabwean authority still does consider public interest. How have you navigated the interpretation of what is in your law? Because to us at COMESA, which is a copy paste of yours, we think that is not public interest as we know public interest. And then if you are saying there's a way in which you address those things, how have you then addressed the issue of uncertainty? Because obviously the emerging parties there would want to exactly know what you're taking into account as public interest. Thank you.
Yeah, thank you, Heather. In fact, it looks like that risk is more heightened in the European Union rather than here. But I think the role of the minister is clearly defined and clearly circumscribed in the Act. And we must remember that in terms of the old Maintenance and Promotion of Competition Act, actually major control was a ministerial role. So with agentification, this role, of course, was then given to the Commission. Of course, there was the old competition board, but effectively this was a ministerial role. So that shows, in my view, that when one looks at the legislative evolution, South Africa has always assigned some form of a ministerial role in major control. So of course that role has now evolved under the new institution. Because the alternative is that if you don't concede some form of ministerial role, especially when it comes to public interest issues, that then you may even lose you may even have the worst case scenario where you lose the agencies and the politicians claim the entire space because there's no accommodation of the executive in the process. So those are some of the pros and cons, I think, that have to be weighed in the debate. But I think under the current Competition Act, the role has significantly improved than it was before. But completely, I think, ousting the ministerial role may have unintended consequences, because if those interests are not accommodated in the process, then that may also create other unintended consequences.
Okay, thank you very much for that question. I think I have to agree with you to say the COMESA regulations are almost similar to the Zimbabwean competition law. On the issue of navigating, maybe let me start by highlighting, I think it's something that you have asked to say, there is always a political kind of interference that comes when we don't prescribe on what we mean by public relations. So by public interest, I mean. So in Zimbabwe, in terms of the institutional structure, which is something again which we are working on. By the way, I should have said that we are actually in the process of amending our Competition Act to try and make it more effective, include things like penalties, which is actually not in our act. We have got commissioners, basically who are political appointees, if you want to put it that way. They are political appointees, and they have the final say. In Zimbabwe, the institutional structure, we don't have a tribunal. So we have the commissioners that make the final decision. And when you want to appeal, you go to administrative court. So it's something, again, that we are trying to work around in the amendment. So when you have that kind of a scenario, my duty as a case officer is basically to investigate and offer some recommendations. Then you have a commissioner there. We have got some kind of political interests and also to offer policy advice. Let me give you a very good example. I spoke about an impact assessment study that was done by the commission. One of the findings there from that study was actually that on some of the measures that were approved by the commission, they actually led to a decrease in exports. How did that happen? So you had that kind of multinational company policy overriding your national policy. So you have a company that is acquired in Zimbabwe, and that company was exporting to Mozambique. Then you hear now you are not able, you are not allowed to export to Mozambique. There is another country that has got secured that market. So you are no longer allowed to export into Mozambique. So that actually led to what? A decrease in exports in some cases. So you present that report to your commissioners and they are reading that. What are they going to say now? Obviously, they're going to say, I think, you know what, when we are going to approve measures next time, we also need to look at issues to do with exports. Plus another point that I made, that we have a trade tariff function again in our act. So you also have those guys from the trade tariff investigation side say, you know what, this measure can actually result in what? In a reduction in our exports. Yet we are actually trying to increase our exports. So it's not easy. But I think we are currently benefiting from the institutional structure that we have at the moment. That is point number one. Point number two, I would say in the past, we haven't received a lot of court cases around our decisions. But this has now started to change. I think from last year, I would actually say, I think there is our lawyers are actually rising from slumber. Because, you know, for I think when in the introduction, there were some remarks that were made around fines that we have imposed as a commission. We have faced a lot of court cases challenging those decisions. And what is also disappointing is something that I think you, Willard, has mentioned, to say these lawyers now focus on technicalities. You know, it's very easy for you know, mistakes are very common. It's very easy for you to make a mistake. So they just say, you know, you didn't do this, and you know, everything then falls down. So that is another point that is making us maybe happy at the moment, but we are also trying to change that now with the new amendments that we are working on at the moment.
So Tatenda, I think your point about the risks of applying these kinds of conditions in mergers or driving the policy is potentially unintended consequences, and that this is not a strategy which is entirely without difficulty and needs to be carefully balanced. Lebohang, you sat on the inside of a competition commission and now sit on our side assisting clients trying to do deals. What are your thoughts?
Yeah, thanks, Heather. So I think I'll focus more on the barriers to increasing or stimulating localization, or the threats even, right, to localization. And I'm going to start with the most obvious one, which a lot of the panel members have touched on, which is the obvious threat of litigation, particularly in the South African context after the amendments to the Competition Act. And I'll explain a little bit how, you know, this threat sort of plays itself out during the merger assessment process and in the context of the public interest assessment, because I think that's where the theme of localization sort of finds itself in the entire merger regulation framework. You know, let me start by saying I heard Bakhe very well saying the Competition Commission's objective is not localization, but some of us sitting on the other fence, you know, you read these conditions that are flowing from the commission, and when you look at the substance, Bakhe, I am sorry to announce, it is localization, right? Yeah, maybe it's semantics, but that's really how it reads, and there's obviously like a clear overlap here and there. I think at least you've admitted to that. So I think the first thing to point out really is that every time you look at a condition imposed during a merger in South Africa, and it looks like a localization condition, it's usually in the context of the commission dealing with one of the pillars of public interest, which is to assess what the impact of a merger is on a particular industrial sector or industry, right? Industrial sector or region, rather. And I think it's almost obvious why that is the case, right? Now, the issue of litigation being a threat really comes back way back, because one gets the sense that in an effort to sort of stimulate localization, competition regulators in particular are beginning to veer away more and more from traditionally established international competition law principles. A case in point, in fact, I suppose the easiest example to make is the example around the principle of merger specificity, right? For those of you who don't know, I mean, when we talk about merger specificity, we're basically talking about an inquiry that a competition regulator embarks on in checking whether what the impact of a particular merger is on public interest or on any of the pillars of public interest. Now, you see, and I think when I emphasize that these are long-standing, internationally recognized principles of competition law, which in fact were recognized in South Africa until what we're seeing now recently, which seems to be a little bit of a shift, because after the amendments, there seems to be an interpretation that you can't have a public interest neutral transaction in South Africa. In other words, our impression, at least, is that the competition authorities are saying the act must be read to suggest that where the merger does not have a negative impact on public interest, it must surely have a positive impact, right? And which is obviously, it clashes with the idea of merger specificity, because the principle of merger specificity basically says that if the merger has got a direct negative impact on public interest, then you ought to then, as a regulator, seek remedies which are going to address those that adverse impact. But what we're seeing more and more, and again, Bakhe, you know, we've got some of the list of cases that we've seen here where the transaction does not have a negative impact on public interest, but there is a call from the commission or the minister exercising his rights of participation for parties to accept a condition on localization, because the parties must make a world a better place, right? Now, the reason I'm saying the risk is a litigation risk is simply because the amendments are not yet tested. We don't really have a lot of a body of work, right, to make sure that this is a correct interpretation that we're seeing, or maybe, you know, the practitioners are wrong. But the reality is that for as long as we're in this bit of a murky scenario where everybody's adopting whatever interpretation they believe is correct, then your risk of litigation is heightened, because it's only going to take one set of facts, one transaction where the parties have the appetite to litigate, and they will take it all the way to the higher courts where we can actually get the score settled, so to speak, regarding the interpretation of the correct interpretation. So that's the first risk, Heather. And then the second risk, and I think a lot of people have touched on these issues, the second risk is the risk of unintended consequences. Now, before I even go into that, I'm quite impressed by the Zimbabweans, because I think they've got something right going on there, right? Because you can't ignore, so whether or not we call it localization, or rather we say the localization drive emanates from some sort of competition framework or policy, whether or not we are ready to accept that, right? The reality is that the two are intertwined, hence the conflict or the tension, right? So I mean, in my mind, having looked at the work of the commission over the years in South Africa, and having seen some of the trade regulations, it's clear to me that there isn't enough collaboration between competition authorities and the trade regulators. And this has played itself out in the past. If you look at the Commission's intervention in the scrap metal industry a few years ago, and ITAC's regulation of tariffs. I mean, we all know that, you know, that intervention caused an outcry in the national industry. So you would think that if things were going as well as they were supposed to, then, you know, there wouldn't be such a reaction. There wouldn't be an outcry. So something is definitely amiss, and maybe we need to go back and look at how we are implementing these systems. And then, but more recently, we're seeing this unintended consequence theme raising itself again during the merger assessment process. And if I can use maybe a case study to elaborate, to sort of speak to this point, Heather. So we have a client in the retail sector, and they engaged in a few transactions, I think most of which last year and the previous year. And in one of the transactions, the commission imposed a localization condition, right? Mind you, there wasn't a credible theory of harm, which was shown on the facts that the transaction would have a negative impact on localization or a particular industry, or there was nothing like that. It almost became like a bargaining, a thing where we knew that from a competition perspective, the case was a bit of a complicated case. So I think what happens generally with business is that when the transaction is complex from a competition perspective, business is more willing to accept some sort of conditions, with public interest in order to try and push the transaction through. But my last reading of the Act says, the question is whether the transaction can be justified, right, on public interest grounds. That's my last reading of the Act, and you'll correct me if I'm wrong, Heather. So the word justification suggests that there's something wrong with the transaction from a competition perspective, and therefore you ought to then go into a public interest assessment, which would hopefully help you justify your very bad competition case in your transaction. But I mean, that's a very loaded debate on its own. So coming back to the unintended consequences and the case study. So our client is in retail, and they had a transaction, and for the reasons I've just explained, they accepted a condition on localization, and the condition was that they would increase their local spend by 50% over the next 5 years, essentially. And that was done and dusted. The transaction was approved on that basis. And then fast forward, the same client comes back. They want to acquire a store. They call them specialist baby stores, right? So your baby cities and those types of stores, your Toys R Us type of stores where there's just a specialist focus on baby products. Now, most of you would know that there's obviously an overlap in the activities of a baby store and a general retailer, right? If you walk into a Pick n Pay, for example, you're going to find mealie meal and rice and other groceries, and then on the other hand, you're going to find milk formula and nappies. So there's obviously an overlap in the activities of a specialized baby store versus a general retailer. Fast forward, what happened with the commission was that, again, and I think I need to emphasize this, the baby store, the target in this instance was in financial distress as well. So this is another issue that talks in my mind to localization, right? So if assets exit because of a financial distress, because you can't get an approval or a reasonable approval rather from the competition authorities, and those assets exit, then you haven't really done much for localization, in my mind at least, So there's just so many of these conflicting themes along the way. Without articulating a clear theory of harm on whether or not the baby store transaction posed a threat to localization or had a negative impact on public interest, the commission nonetheless requested the parties to agree to a condition to increase or improve localization, right? And our view was that, well, if you study the market properly, for you to drive localization, you have to have a little bit more insight into the market you're dealing with. So it's not only just limited to the facts of a particular case, but you need to understand the market. And our defense was that part of the reason the baby store went into financial distress is because there's a bit of pressure from the general retailer space, right? That's the first thing. The second thing is, in order for a baby specialist store to differentiate itself from a general retailer, you have to focus on imported products. It has to be bespoke products. It has to be certain branded products. I mean, I know I've seen, I haven't had a baby recently, but I've seen people walking around with Ferrari baby strollers and you know, car seats. And this is what this client was saying, that if I am to remain competitive as a specialist baby store, then I need to sell products like those. And interestingly, from a trade perspective, the tariffs which relate to these particular products are very nice and low. I can import these and sell these at a premium in South Africa without offending the Competition Act and without being accused of excessive pricing. Whereas the Commission, on the other hand, is saying, no, we want you to localize more. So there's a clear attention that arises from, you know, not seeing enough collaboration between the trade regulator and the competition regulator, which at the end of the day may very well end up you know, resulting in these unintended consequences where you've now basically potentially killed a baby store because you're trying to force them to source products locally when what they actually need is to import products. And I think
I'm going to stop you there.
All right.
Okay, I'm sorry, we're running out of time, but I think we'll take one more round of questions. Would anyone like to ask a question? Derek, Eddie. Hello, Eddie.
Thanks very much for a wonderful discussion and event. So nice to see everybody again. Just a question. You know, it's one thing to talk about localization in the context of merger conditions, because, and Bake, this is probably a question for you. When you impose public interest conditions or localization conditions in merger context, it is the merging parties that will subsidize that localization plan. Now we are at master plans, so that's just on the periphery of merger conditions. It's still the same policy issue of localization. We are now at master plans. That can have the consequence of increasing prices, not because of any collusion, which the guidelines serve to avoid, but because of lesser competition. And who's now paying the bill? Not profitable merging parties, but the end consumer, who's very cash strapped, especially now. They can't afford Ferrari prams. So my question is, Bake, are those products and the prices of those products that are covered by the master plans, are they tracked on a continuous basis? That's the first question. And secondly, will the Commission have the independence to stand up at some point and tell the Minister the consequences, which is not unintended, it is probably, well, it's not unsuspected, it is something that can very well happen. The consequences are now just too severe from an affordability in consumer perspective, because it's the end consumer that subsidizes, strictly speaking, those master plans. Thanks.
But the question about master plans, Bake, and competition tracking, I mean, I know you guys have got your essential monitoring price report, which covers food, right? Are you starting to track anything beyond that, linking into the master plan process?
Yeah, I think I've made this point very clear, that the Commission is not the regulator of localization. I must repeat that point again. As Lebo was speaking, I was furiously looking for a passage in the Walmart judgment, and I finally found it. If you may indulge me, Heather, it's a very short paragraph.
Sure.
It's paragraph 98 of the Walmart judgment. It says, viewed holistically, there is merit in the argument that the Act should be read in terms of an economic perspective that extends beyond a consumer welfare approach. By virtue of an embrace of the goal of a free market and effective competition together with an incorporation of uniquely South African elements, including the need to address our exclusionary past, which need is reflected expressly in the preamble, together with Section 2 of the Act, the legislature imposed ambitious goals upon the competition authorities created in terms of the Act. Within the context of the present dispute, this ambition is further captured in Section 12A, which mandates an inquiry into substantial public interest ground. I think this provides, in my view, a complete answer to what Lebo has raised.
Only I have raised.
Yeah, so I think the other points which have been made, of course, this issue of major specificity will always be contestable and will always have to be assessed on a case-by-case basis. But certainly, it is not, if an impression has been created that we have jettisoned the major specificity constraint, which is a legal requirement, I think I need to dispel that. That is certainly not the case. There may, of course, be a debate between the Commission and the parties about whether or not certain concerns are major specific, but definitely that still serves as a guiding standard for our assessment, both in relation to competition as well as in relation to public interest issues. Most of the public interest remedies that we have imposed are usually driven by concerns from stakeholders about the impact of a merger. So these are usually not imposed in a vacuum, but there is a rational basis for where the Commission imposes this. Of course, there is a process in terms of which parties negotiate with the minister and agree on a package of remedies. The Commission is not involved in those negotiations at all. And we are usually then presented with an agreement that has been reached between the minister and the parties. So insofar as the Commission is concerned, I think we have always been, I think, adopted the approach that is guided by both the Act as well as the jurisprudence. Thank you.
Thanks, Bakhe. Tatenda, do you want to come in there? Any comments?
Not necessarily related to this, but I just wanted to make a comment on, it relates to the discussion though. I just want to borrow from the remarks that was made by the judge in the morning, and also from what Willard shared in the discussion. I think we find ourselves as Africans in a situation whereby we are trying to develop a local industry. And at the same time, we are also trying to make sure that industry is competitive. There's competition, there's rivalry. So there's a question that arises now to say, what comes first? Is it the development of local industry and then you regulate? Or is it competition and then you develop a local industry? So that is a very, very tricky question to answer. But I want to refer to an article that I was part of my master's reading notes. That article was written by Professor Alice Amsden and Anjit Singh. I think it's an article that I would recommend, I think some of us here to read it. It is a 1994 article. The title is called Optimal Level of Competition and Dynamic Efficiency in South Korea and Japan. So I'll just give a brief summary of the article. So what they did in that article, they looked at how Japan developed around the 1950s, where there was high growth, 1950s to 1970s, and also South Korea. So there's something that is quite stunning from their finding. One of the issues that they raised was that these countries had an industrial policy which was more powerful than competition and trade policies. So what would happen now is that in Japan, for instance, there were cases where government would actually force companies to merge. And I want to refer to what Thomas shared in relation to EU, where he was talking about those train companies trying to merge. That is exactly the point that was raised, to say you want to create national champions that will be able to compete at a global level. So there were times when they actually forced companies to merge. But actually, I think in EU, it's actually a different story, which now brings me to my conclusion to say, I think there is really need to balance, to balance between competition and also industrial development. Also looking at the context to say, if you are in South Africa, what is it that we need to look at? What is it that is we are going to benefit from competition and also from industrial policy? You'll find again that they also make this finding that in South Korea, it was also the same thing. So government sometimes would actually encourage companies to form cartels. So it's not a popular, it's not a popular article, but they actually at times where government would actually force companies to get into cartels. And why would they force them to get into cartels? They wanted these companies to be able to get as much profit as they can and also reinvest. But the key thing about all this was that there was competition. That does not mean that competition is not there. So they had systems in place, what I would call what they call reciprocal control mechanism, where there were a system to say, if we give you this advantage to form cartels and whatever, you must in return you have 1, 2, 3, 4, 5 things. So I think for me, that is what is very, very important to say. You need to contextualize the situation and also try and also balance the relationship between competition policy and industrial development and trade policies. So thank you very much.
I'm really sorry, but we're going to have to wrap up this afternoon. Thank you to our audience for the great questions and more enthusiastic participation. And Bakhe, thanks so much for joining us. I know you had to juggle lots of commitments. And to Tatenda and Thomas, thank you for traveling to be with us. It's been a pleasure to see you in person. And Lebo, thanks for keeping it real as always.